Good morning, everyone, and welcome to our Enrich in China webinar focused on IPR protection in China, in this case with a thematic focus on the healthcare sector. My name is Vasco Barros. I'm a project manager at SPI, and we are the coordinators of the Enrich in China Center. This webinar will be provided as a service from Enrich in China. So welcome everyone, and thank you for joining in time. I will be now briefly mentioning and going through the agenda and what we have for today. In the beginning, we will have a presentation from our experts in IPR. His name is Tom Carver. He is an expert within the network of the China IPR Helpdesk, and he will talk about some IPR elements and issues in the protection in China, more oriented to the healthcare sector. After that, we will have a presentation from Richard Deng, chief representative from SPI China, and he will be presenting some more details of our upcoming matchmaking tour to China, which will also be focused on the healthcare sector. So this will be all within the health topic, and he will present more details about the program and some information of the cities and the conferences that we will attend. And at the end of the session, we will have some space for questions. These questions can be made by any participant, and you may find on the right side of the screen a section where it mentions questions, and I will just ask you to make your questions by written there, and then the questions will be asked orally, and the speakers will give answers to them. So feel free to make questions during the presentation, and we will make sure to answer them. If we have any time constraints, we will make sure to answer as much as we can, but if the time does not allow, we will make sure that the questions are saved for later, and we will direct them by email to our speakers, and they will make sure to reply to your questions, and we will make the questions reach you and the answers. Okay. You may also find attached in the system, in the handouts, the presentations that will be delivered during the webinar, so you may also have access to them separately and keep them to you. So you have all this information. So just briefly presenting the speakers, as I mentioned, we have Tom Carver, an expert from the China IPR Helpdesk. Just briefly explaining what the IPR SME Helpdesk is. This is an EU initiative to support European organizations in receiving first-hand information on IPR issues that they have. They reply within 48 to 72 hours to any request. And they give you first sight information to any of your issues. However, this does not replace any more technical and detailed support and advisory for many other lawyer office. But this is a really important step towards obtaining more information regarding a specific market. In this case, Tom Carver is connected with the China IPR SME Helpdesk, but he is a partner at J.A. Kemp, and he is a specialized lawyer in intellectual property with a lot of experience between UK and China. He's currently based in London, but has spent 3 years living in China, advising clients on enforcement and intellectual property rights. He also advises Chinese companies on UK law, and is a regular speaker on topic regarding IPR in China. After, we will have, as I mentioned, Richard Deng. He's a chief representative from SPI China, and he is with SPI since its onset, and is the full responsible for all the operations that we have at SPI China office based in Beijing. So without further ado, I would give the floor to Tom. I will, in the meantime, pop his presentation up. Okay, just 1 second. Okay, Tom, I would pass on the floor to you, and please go ahead. Thank you very much.
Okay, thank you, Vasco. Good morning, everyone. Thank you for attending. I'm going to talk, as Vasco said, about IP protection in the healthcare sector. So as long as the slides work. Right, so first of all, I'll just tell you a little bit about the China IPR SME Helpdesk. This has been going for quite some time and is a very useful resource for SMEs. There's a helpline, there's lots of newsletters and IP guides that are updated fairly regularly, a website and a blog. And as Vasco said, there's an inquiry helpline with advice delivered by specialists. Sort of first advice. Obviously, they can't give detailed advice because they're not insured to do so. Not it's general advice only, but it's a very useful resource. And I recommend the website to you for a browse if you're looking for information. There's lots of stuff there, industry-specific guides, business guides, etc., and different country fact sheets, because of course mainland China, Hong Kong, Macau, Taiwan all have different laws to a certain degree. So it's very useful. So today I'm going to just talk about Chinese IP. That's me. Vasco's already introduced me. No need to talk about me anymore. And so Chinese IP rights. Now, this is going to be quite sort of aimed quite basic, so forgive me if you know all this already, but I was told to keep it fairly high level. Chinese IP rights, what are there? Well, there's basically the same IP rights that you get in most countries. There are patents. We'll come on to the difference between those three types in a second. There are trademarks, there's copyright, there's unfair competition, which is a bit like passing off in the UK. And of course, there's the use of trade secrets and non-disclosure agreements, which is a contractual right rather than an IP right, but nonetheless is part of one's toolkit when doing business in China. So patents, well, there are three sorts, as I foreshadowed on that slide. There's invention patents, utility model patents, and design patents. And these more or less correspond to rights that we have in Europe. So an invention patent is what we would refer to as a patent in Europe, so a European patent that you get from the EPO. And that lasts for 20 years and covers inventions, so innovations that are new, inventive, and susceptible of industrial application. And I'm sure you're all very familiar with that. There are then something called utility model patents, and these are not so common in Europe. Some countries have them, for example, Germany, and others do not. For example, UK, we do not have utility models here. And these are sort of, for those who don't know, these are sort of less inventive innovations. So in order to get a utility model patent, it's got to cover a technical solution, and it's got to be new, but the test for inventiveness is not quite the same as for a patent. And they last for 10 years. Due, I think, to be increased to 15. There's an amendment to the patent law, the fourth amendment to the patent law, which is due to be introduced sometime either this year or next. And I think that utility model patents are being extended to 15 years. The last type of patent is a design patent. And this is what we in Europe would generally think of as a registered community design. So it covers the same things as a registered community design. And that is original designs relating to the shape, pattern, color, or combination of an object. And that lasts for 10 years. So in the sort of medical area, one would think, inventions are good for pharmaceuticals and for inventive medical devices. Utility model patents are more aimed for the sort of mechanical type things, utility model medical devices, and then design patents, of course, are more at devices. Most important thing to consider when you're filing patents in China, and I'm talking about an invention patent here, which is, of course, the one that relies on text in the claim. and also utility patent to a certain degree, is translation. Only the Chinese text will determine the scope of the claim, and same as in Europe, only the original language text will define the scope of the claim. And when translating technical information and new technical information, it's a very difficult task. And so it's important, really important, when you're filing in China that you use a good firm that ensures that the translation is fully accurate, because there's no way to fix a bad translation. If you have a patent that's translated badly and the scope of the claim is not what you thought it was, there's no way you can change that. So that's really important. Moving on to trademarks. So trademarks in China have not a great reputation because of this first to file system. So in a number of jurisdictions around the world, one can have rights in a trademark just from using it, rather than actually having filed it. And so if someone comes along and files a mark that you're already using, you have rights against that person. But that's not the case in China. So in China, they have a first to file system. And that just means, as it sounds, that the first person to file the mark owns it. And this has led to a sort of mini industry of what's politely called trademark speculating, and less politely called trademark squatting. I'm sure you've all heard about this, and it's a big problem. The speculators are, they're pretty professional about it. They go to trade fairs, they scan the internet, and they file Chinese trademarks for anything they think looks interesting. How do you avoid this? Well, you just got to make sure you file early. So as soon as you are starting to think about selling in China, or indeed any sort of business in China, you should file. File your mark that you use in the West, and also you should think about filing a Chinese version of the mark, because inevitably, if you don't, then a local name will spring up, a local nickname will spring up, and that may be what it's known as, and then you won't have the rights to that name. So you should file the mark that you use in the West, and you should file a Chinese version as well. What can you do if you start doing business in China to find that the speculators got there already? Well, as I said, it's very difficult. Either a mark can be cancelled after 3 years of non-use. So obviously the speculator or the squatter is not going to be selling products using that trademark, so they're not going to be using it. So you can wait for 3 years and then apply to cancel it. Or you can try to prove that the speculator registered it in bad faith. This is very difficult. Really, it relies on there having been some pre-existing connection between the squatter and you. So perhaps it was your distributor or someone like that, and you fell out and they registered this mark, and you can show they did it in bad faith. But just a regular trademark speculator won't be found to have registered in bad faith, so that generally can't work. Your last option is to try to buy it from them. After all, that's why they've registered it. That's a business, and that's what they want. How much you have to pay really will depend on how good at negotiating you are and who you are. Famously, Apple had to pay $60 million a few years back to get its iPad trademark back in China. So that's a pretty hefty sum. But of course, that's Apple. More generally, you might be thinking of a few $1,000s or a few tens of thousands of dollars. But whatever it is, it's still a bit of a hit. So it's best to try to avoid that and file your trademark early on. Then we have copyright. So copyright, same as in the rest of the world, copyright arises automatically in creative works. And China then has a system of recordal, a bit like in the United States of America, and unlike in the UK, so UK and I think most European countries, there's no recordal system. But in China there is, and it is generally recommended that you record your copyright, or at least important copyrights, because that makes enforcement an awful lot easier. The most tricky bit of enforcing copyright anywhere in the world really is proving that you own the copyright. And if you have recorded it at the National Copyright Administration, then that task is made much, much easier. And so it's very highly recommended that you record any of your important copyright. So copyright generally arises for any sort of text or artwork. It doesn't have to be particularly artistic, so product leaflets, websites, advertising, etc. can all qualify for copyright as long as there's some sort of creative freedom involved in creating it. Unfair competition we mentioned earlier. So this is a right that's similar to the sort of UK passing off or the European unfair competition right, and it protects the look and feel of a product. This is very difficult to rely on in China. And it's difficult because firstly you've got to prove that the original was very well known. Now you are all SMEs, and I suspect therefore not currently well known in China. And so effectively it'd be extremely difficult to rely on that. I've only ever used it once in China, and that was for a very famous mobile phone company. And the infringer, very strangely, the infringer had created an entire shop pretending to be a shop of this mobile phone company, selling its sort of reconditioned products and one thing and another, and we managed to have it closed down. But that is because the client had a strong reputation in China. So not really one to rely on if you don't. So we have trade secrets and non-disclosure agreements. A lot of people, when they go into China, say, well, you know, what's the point in signing a non-disclosure agreement, because it's not going to be enforceable, and the Chinese parties that we like to deal with always say not to worry, you know, it's all about guanxi, and not to worry about contract. To that, I would say that I would always sign a contract if I can. As they say in China, the palest ink is better than the best memory. And if you at least have things written down, then you have certainty of what you're agreeing, which, as we'll come to in one of the case studies, is very important. And you have evidence of that commercial agreement should you ever need to go to court. And of course, if you didn't commit it to paper, then you have neither of those things. So a couple of points to note when you're drafting contracts, and this applies to all contracts, not just to NDAs. So the language, this is important. What language should it be in? Your home language or Chinese? Well, first thing to note is that the Chinese court is not going to want to look at a contract that's not in Chinese. So depending on what jurisdiction you choose later on, you may be forced to have it in Chinese. If you're doing that, then it's often nice to have it bilingual. So I usually do these contracts in bilingual. You have the clause in Chinese, and then you have the clause in the home language of the other party. And that usually works quite well for both parties. Damages. It is possible to insert a liquidated damages clause into a contract, and generally I'd recommend this in China. One of the difficulties in any sort of litigation in China is proving damage. I won't go into it now because it's long and complicated, but effectively the evidential system in China is such that it's very difficult for a claimant to prove damage. So if you have a liquidated damages clause in your contract, and by that I mean a clause that specifies a certain sum of money in the event of a breach, then as long as that sum is deemed reasonable by the court, then it is much easier to enforce. So I'd recommend including a fixed or liquidated damages clause. Then jurisdiction is always an interesting one to consider. Usually parties like to have their own home country jurisdiction, and people get very nervous about submitting to the jurisdiction of a Chinese court. But you've got to think about the enforceability of any decision. If you get a decision from an English court or a French court or a German court, then the Chinese court is not going to enforce that. So effectively, you've just got a Pyrrhic victory, and it's not going to be enforceable. If you want an enforceable contract in China, you've got to have a Chinese court making the decision. The exception to that is arbitration. If it's a high value contract and you don't want to trust a local Chinese court with it, then usually Chinese parties are content to agree to an arbitration clause, and usually content to agree to a non-Chinese center if that's what you want. Singapore or Dubai are common choices, parties who want to have an arbitration center halfway between China and Europe. Otherwise, you can go with the CIETAC, which is CIETAC, which is the Chinese arbitration body, and they tend to be pretty reliable and pretty good. And the great thing about arbitration, as opposed to foreign court jurisdiction, is that arbitral awards are enforceable in China. And even now, recently, an interim injunction granted by an arbitral body was enforced in China. A Hong Kong arbitration panel granted emergency relief, and the Chinese courts agreed to enforce it. So arbitration can be a good option, but obviously it costs a bit more money than court, because you have to pay the arbitrators, and the procedure might be a bit more involved than in a Chinese court. So move on to enforcement. So you've got your right, and you find someone infringing. What do you do about it? Well, similar to most areas in the world, the first thing to do would be to write a letter before action and try to nip things in the bud. And of course, similar to most places in the world, the reaction to that will kind of depend on the defendant. If the defendant is well entrenched and has spent money on buying molds or plant or machinery to produce the infringing product, then they're going to be fairly reluctant to stop. But if they're just a sort of reseller, then you should be able to nip it in the bud quite early. If that fails, you can have a choice of administrative actions, civil litigation, or criminal sanctions. Now, criminal I'm not going to talk about. I've never got involved in criminal. It's very difficult to persuade the local PSB to take action against a local company, and something would have to be truly egregious to warrant that. So generally you have either administrative or civil. Civil is what we in the West think of as litigation. You go to court. This is generally improving in China. They recently introduced, in 2014, they introduced specialist IP courts in Beijing, Guangzhou, and Shanghai to try to concentrate the sort of IP expertise. And those courts have been pretty successful, and it's been rolled out to a load of IP tribunals around the rest of the country. And then at the start of this year, the appeal structure was altered. So in the past, you would go to the local intermediate court or the local IP court for first instance, and you would appeal from there to the local high court, and from that high court to the Supreme Court. And the trouble with that was that the high court might not necessarily have had much IP expertise, and there was some perception of protectionism in some provinces. So that level has been removed now, and you would now appeal directly from the local intermediate court or the local IP court straight into the IP tribunal of the Supreme People's Court. So this is an attempt to improve consistency of decision making, because of course there's no doctrine of precedent in China, and so this kind of and decisions weren't public, so it was very difficult to get a sort of consistent decision making across the country. And hopefully having the Supreme People's Court as the first court of appeal, a bit like the sort of federal Court of Appeal in the US, will improve the consistency of decision making. That, of course, is at the expense of one of the layers of appeal. In the old days, you would have your first appeal to the High Court and then a second level of appeal to the Supreme People's Court, whereas now you will lose that second level of appeal. But I think on balance, it's probably a good thing and should improve matters. Administrative action is a bit like, we don't really have an equivalent, certainly in the UK. It's kind of like a trading standards body, so you don't go to court for administrative actions, you go to the local administration of industry and commerce, and they will raid factories for you. They can grant injunctions and they can prevent infringements, but what they can't do is give any damages. They can fine defendant companies, but not give damages. So the AIC administrative action is quite good for sort of small, low-level infringers who you want to shut down very quickly, because it's significantly faster procedure than the court, but not if you're looking for damages. So just to recap on the key points, it's very important to register your rights, especially your trademarks. Important to do due diligence on your business partners. So as well as your NDA and you're protecting your trade secrets, make sure that the people you're doing business with appear to be trustworthy, and enforce your IP rights. It's all very well applying for your patents and trademarks, one thing or other, but if the word gets around that you're not enforcing them particularly vigorously, then China is it's a big place, but it can also be a kind of a small community in towns. Word might get around that it's okay to produce such and such a product because the IP owner appears not to be taking a strong line on enforcement. So with that, I'll just run through a couple of case studies. Now, these aren't actually in pharmaceutical, medical areas, but I think the lessons in them are appropriate. And I picked these ones because they're just such striking examples of what you can do wrong or right when you're trying to do business in China in terms of IP. So the first one was actually a watch company, a big watch company. They were making 400,000 watches per month in Shenzhen, which is a city down in South China. I'm sure you've heard of it. So 400,000 watches. I mean, this was a significant company. But it turned out they hadn't registered any IP in China at all. No trademark, no design patent, nothing. And so, of course, when you have something, a product that successful, huge numbers of counterfeit watches were being made and sold in Shenzhen. So rather belatedly, they tried to register their trademark, but of course, someone else had already got there first, the trademark speculator. So they were in a bit of a bind. What could they do? They could try to wait for the 3 years non-use, but this was A, slow, and B, actually, the infringers were using the trademark. So there's a question mark over whether that would have worked anyway. They could have tried to use the anti-unfair competition, but this wasn't really going to be a runner because they didn't really have the reputation in China. They made these huge numbers of watches there, but sold them elsewhere. So they didn't have a reputation to rely on. So they really were rather in the mire. So the only thing they really could do was wait for the 3 years non-use to expire and then cancel the mark. And that was 3 years of wasted time while these counterfeits were on the market. And it all could have been avoided had they registered their trademark early on for just a few £100 per mark per class, or even a design right. You know, if they had registered the designs of their watches, their watch faces, they would have had something to rely on. But they didn't. So that is an object lesson in what not to do. The next case study is a license. It's a contract case study, and this is all about translations and being careful and just generally doing what you would do in Europe. It's funny, when people get to China, they sometimes have a sort of rush of blood to the head and don't take the steps that they would normally take in Europe, because they think, oh, well, it's China and everything's different over there, and this guy assures me that he's got my back, so I don't have to do what I would normally do. So this client of mine was a special effects manufacturer for theatres. It makes the sort of kit that enables actors to fly through the air on stage. So they had IP in the hardware, but more importantly, in the software that controlled the speed at which the actors flew through the air. Now, the parties had met and agreed a deal before I got involved, and that deal was for the US company to fit out one theatre and to provide the software for that one theatre. So the Chinese party drafted the contract, which I then examined, and it had this IP clause. It said if the owner, so that's the theatre owner, needs to use seller, so that's my client, the American company's intellectual property for the purposes of application for use of the above-mentioned new intellectual property rights, the seller agrees the owner or its associated companies may use their intellectual property rights free of charge. The owner or its associated companies may use their intellectual property rights free of charge. Now that, you know, is a rather oddly, badly worded clause, but effectively it sounds like a perpetual royalty-free license to all of my client's IP. The seller agrees that the owner may use their intellectual property rights, I mean all of them, free of charge. So we responded. We said, look, the verbal agreement was just one theatre, and so we're only going to give one license, and so we sent back a redrafted narrow clause. But the Chinese party resisted. They said, no, this wording is fine. Don't worry about it. It's the Chinese version is a bit different, you know, the Chinese translation. So don't worry. Of course, it's as per the verbal agreement. But we weren't really satisfied with that. So we went and I flew up to Beijing, where they were based, and we had a meeting which lasted something like 6 hours of talking. And eventually, the Chinese party admitted that, yes, this clause was the same in Chinese, and it did aim to give them a perpetual royalty-free license to all of our IP. So having learnt that, the American client abandoned the project very sensibly, because it would have completely destroyed their business in China. So the moral of that story is to insist that your contract is properly drafted, which of course you would do in Europe. So just make sure you do the same thing in China, and make sure the translations are accurate and they say what you think that they say. So that is all I have to say, and I've come to the end of my half hour. So here's a few other ways to follow the EU IPR SME Helpdesk. And good luck doing business in China. I think I'll be sticking around for a few questions at the end, if anyone has any. And with that, I'll hand back to Blasco.
Thank you, Tom. Thank you very much for the great presentation and for all the information and advices that you gave regarding this topic. I have also been in China, and I know how these things are important, and it's important to be protected. And it's never too much information on this topic. So I will now give the floor to Richard Deng, as I mentioned, Chief Representative from SPI China. And he will give more insights on the upcoming tour to China on focused on the healthcare sector. So please, Richard, the floor is yours.
Thank you, Vasco. Good morning, everyone. I'm going to make a short introduction about ENRICH in China in general, and then I will present coming matchmaking tour organized by ENRICH in China in April to 2 cities, Beijing and Wuxi. Sorry, previous. Sorry about QA. How? Okay. So the next slide. Okay, how ENRICH works in China. So basically, ENRICH in China is a project funded by the European Commission with the Horizon 2020. It aims to support European innovators, including startups, SMEs, and research to approach the Chinese market. So to help them connect and support science technology cooperation with China, and to further reinforce the leadership of a European STI in the Chinese market. For the consortium team, in total, we have 8 European partners from different member states, country, and you can see here. So SPI in Portugal is a coordinator, and then we have Fraunhofer IPK standbys from Germany. We have EU relationships from Switzerland. We have EBN from Belgium, Brussels, and we also have Innovation Norway from Norway. And we have FFG from Austria. We have Paris from Greece. From the China side, we have 5 Chinese partners, and 2 are from the Ministry of Science and Technology China, called Torch and SysTech. And also we have a very good partner, a leading university in China, Tsinghua University. And then we have another partner, UPIC, based in Chengdu. And then we have the 5th one, the University of Nordinghai in Ningbo. So ENRICH was officially launched in January 2017, and then we launched our headquarters in Beijing in November 2017, hosted by EU SME Center. It's also initiated by the European Commission. And ENRICH has a liaison office in Brussels, hosted by partner EBN. And then in China, we also have a regional hub based in Chengdu. It's hosted by UPIC, a Chinese partner. So who are ENRICH's clients? So basically, we support research actors, innovation actors, and also business actors to help them to approach the Chinese markets. So different organizations could be ENRICH the clients, for example, like the universities, research center, and research councils, and also innovation agencies, funding agencies, and other STI networks and platforms. And also those small companies, startups, and class management organization, and the business association, and chambers, and also large companies who are interested in link with small companies, technology-based small companies in China. Sorry, how can I move to the next slide? Does it work? Okay. Sorry, too much movement. Let me see. Okay, so what do we do? So ENRICH, sorry. So what we do? So ENRICH offers different types of services to Europeans who are interested in the Chinese market. Here just seven catalogs of services ENRICH is offering now. RDI consultancy and coach. So basically this kind of more traditional kind of consulting services, customized one-to-one specific requests. And then we also have RDI intelligence and software learning and co-working innovation support certification, and fostering open innovation through training and cooperation enabling events and RDI briefs. So I won't go through them in detail. You may visit ENRICH website for more details about all those different types of services. And next, I'm going to present a great ENRICH matchmaking tour we are organized now in April to two cities, Beijing and Wuxi. So basically, this is a one-week program for the health companies and the relevant organizations to join different activity in Beijing and Shanghai. To have the chance to present themselves to the interesting Chinese companies and other associations and stakeholders to see the opportunities in the Chinese healthcare markets. So the tour starts from April 8, Monday. So arrive in Beijing. And then the ENRICH project team will brief the tour program to all the participants. And Tuesday morning, we will have a very interesting session called Nordica in China 2019. So this is a very interesting session with focus on smart city, sustainable development program, also including smart health solution. It's a very big event. Many interesting organizations from both European and Chinese side will attend. So you will have a chance to interact with different Chinese stakeholders. And then in the afternoon, we will have a seminar, China International Smart Health Care Solution. So this seminar will focus on healthcare sector. We have very good speakers from both European and Chinese side to talk about the opportunities and challenges in the Chinese healthcare market. And then Wednesday, we will organize business visits to a very interesting Chinese biotech pharmaceutical science park. And then in the evening, we will fly from Beijing to Wuxi. And then Thursday, in Wuxi, we organize business visits to a very interesting pharmaceutical company in Wuxi. And then to have B2B meetings with Chinese participants. So the European tour participants will have a chance to present their company, their business plan about China, and to see the potential opportunities for cooperation. And then we will also visit a very interesting science park called Mashan Life Science Park in the afternoon. And we will also have a networking lunch in the during the visit. And then Friday, we have in the morning, we have the opening session of the China Wuxi International Healthcare Forum. This is a very large event with participation from many international visitors and also Chinese healthcare stakeholders. And in the afternoon, we will have our own session about healthcare cooperation between China and Europe. We also have very good speakers to make keynote speech, and then the tour participants will have a chance to present their companies and their cooperation intention with China. And then Saturday, you will have a chance to visit a free tour to the China WuXi International Medical Equipment and Pharmaceutical Supply Chain exhibition. It's a very large exhibition in China. So this slide is about Beijing. I think most of you know Beijing. Beijing is a very large city, and it's a capital of China. In terms of health sector, it is also very well developed and advanced for different healthcare sector, pharmaceutical, biotech. There are quite a lot of innovative companies engaging in healthcare technologies. So I will then go through a little bit more in detail about activities on each day. So this is the first day, arrive on Monday in a hotel, Great Wall Hotel in Beijing. It's a very convenient place. And then we will have a brief in the afternoon, mid-afternoon, about the tour program to all the tour participants. And then a short introduction about Nautical Age Expo. So this is a very interesting big event organized every year. Last year I was organized in Norway, and this year IPR organizing in Beijing. So you will meet quite a lot of different people from different organizations, companies, associations, government authorities, and investors from both private and public sectors, Europeans and also Chinese. So it's a good opportunity to networking with people who are engaged in Sino-EU cooperation. This is just a picture, some data, numbers about the Nautical Age last year, 2018. It took place in Norway. And then the program on Tuesday. So in the morning, we have this Nautical Age session. We have very good keynote speakers from both European and Chinese side. And the ambassador to China of Norway will attend as well. And in the afternoon, we will focus on the healthcare sector in China. Dr. Sarah Medina from SPI will present ENRICH in China and how ENRICH help you to grow your business in China. And we also have a speaker from European Chamber of Commerce in China to talk about the chance and challenges for medical device companies in China. And we also have another Chinese meeting speaker. We'll talk about opportunities, challenges in the Chinese pharmaceutical market. And then we have a speaker from IPR Helpdesk as well to talk about how to register your IP in China. And in the second session, the tour participants will have a chance to present their companies and their business cooperation intention about China to the audiences. And then on Wednesday, we will visit a very interesting pharmaceutical science park in Beijing. And in the evening, we will fly from Beijing to WuXi. Little bit introduction about WuXi and particularly this Mashan National Life Science Park. So this is a very important life science park in China, and it has been operating since 2008. And now more than 200 Chinese technology-based companies are located there. They are engaged in different technologies like the biomedicine, health food, medical instrument, outsourced services, and medical devices and other equipments and healthcare treatment services. So this is a very well-developed science park with many Chinese companies there. And this is about the big event forum in Wuxi. So the theme of this forum was biotech, pharmaceutical innovation, and capital finance. So the idea is to have good technology companies and connect them together with potential investors and to invest in new technologies in this healthcare sector, and to generate more cooperation between Chinese companies and European companies and other international companies. So this is a program for Thursday. So in the morning, we will visit the company in the Marshan Life Science Park, and then the European participants could present themselves and to see potential collaborative opportunities, cooperation opportunities with Chinese companies. And then in the afternoon, we will also visit two other interesting Chinese healthcare companies in the Life Science Park. And then we will have a reception dinner to networking with different Chinese healthcare stakeholders. Just a few speakers in Wuxi. So we have Mr. Han Chen Abigail from Stanford, from Germany, and we have a very good professor from University of Ningbo, University of Nottingham Ningbo in China, and we also have Mr. Nemes from a very interesting company in Hungary. This is an agenda for our healthcare workshop in Wuxi. So here we have very good keynote speakers from the EU delegation to talk about the IP with focus on the healthcare sector. And also we have a leading professor from the USA will talk about the deep learning technology, and there a very interesting project about China-EU cooperation in healthcare sector called CNET, also funded by the Commission with 12020. Were presented by the coordinator, HM from Stanford, and then again Dr. Sarah Medina will present ENRICH in Wuxi. And then in the second session, the tour participants from Europe will present their companies to the Chinese audience. And then lastly, Saturday, you will have a chance to visit this very interesting and large fair, China Wuxi International Medical Equipment and the Pharmaceutical Supply Chain exhibition. This is a very large exhibition in the east part of China, and many Chinese companies and also international companies in healthcare sector will have a booth there. So you will have a chance to interact with many different healthcare industry players at the fair. Okay, so basically this is the program for the ENRICH tour in China. We are still open for registration, and we hope you to join with us for this great tour in April in Beijing and Wuxi. Thank you very much for your attention.
Thank you, Richard. Thank you very much for for the detailed information on the program and all the insights of ENRICH, which is also useful for everyone attending. What does ENRICH do and how it supports European organizations? I have a question here actually for Richard. So I will ask Richard for you to answer. This question is specifically regarding ENRICH. So the question is, are the services offered by ENRICH, example of the consultancy, are they free of charge for EU organization, or how does this work?
Okay, thank you, Vasco. So basically, ENRICH offers services to European companies, but it's not totally free. Some of our services are free. For example, such kind of webinar, it's a free registration. But for some other services like the consulting services, RDI consulting, it's charged. Of course, normally it depends on your specific requests. It's kind of a customized services depending on your specific request. So normally we need to better understand what exactly you need and say what we can do, and we will come up with a proposal with a
Richard, I think we lost your connection. Could you check if the sound is working? Okay, I think we lost Richard for the moment, but yes, I will finish off the answer to this question. So yes, this is a charge fee. However, it's a very competitive fee compared with the benchmark price of the market. Since this is an EU initiative, and we want also to provide tailor-made and high-quality services to our clients. And the services are currently provided by the European and Chinese partners of the consortium of the project. So as I mentioned, this has a fee. So we also have the commitment from the participant, from the clients in this case, that they are really also all in with us in the process. But as I mentioned, it also depends on a case by case, depending on the needs of the client. And also what they envision and what they want to establish in China, what is the full support that we can provide. So in this case, it will depend, but feel free to contact us by email as you have the address on the screen, and we will be glad to arrange a call or to provide more details of more concrete information. I have a question here for Tom, if that's okay. The question is the following: in case of bilingual NDAs or other documents, if there are discrepancies between the two language versions, which will prevail? I think you have answered this question, but if you wouldn't mind answering it.
Sorry, my line's not very good when I'm listening. If there's discrepancy between the two?
Between bilingual NDAs or other documents in both languages. If there are any differences, which version in terms of language would prevail?
So it depends on the contract. Normally, in a bilingual contract, you will specify which language is the correct version. So you would say it's either Chinese or it's English or Portuguese or whatever it would be. But there would be a clause in the document to specify which language should prevail.
Yes. Thank you very much. I'm also checking here other questions. I have also a question here which I will be answering. In this case, a question which refers the availability of the presentations in the that were presented. Yes, they are currently available in the handout section of the system. So if you go to the system on the right, and you have a section where it mentions handouts, at the moment you can make the downloads. As far as I can say, the download of of the presentations. I will just check if all the presentations are there. So just give me 1 second. But in the meantime, I think some of them are already there, so you can access them. Okay, I'm just checking. I believe that there's one presentation which currently is missing, and I believe it's the one from Richard. So I will be adding this right now. Okay. Okay, I have just inserted the presentation from Richard, so you'll also be able to download this presentation. I'm going to quickly check if there's any other question. There is a point here referring the contact from the organizations of the tour, getting access to them without participating in the tour. I'm guessing. This is information that is just shared among the participants of the tour, their profiles and contacts. So this will not be available for external people which will not be attending the tour. Okay, I think that for the moment we do not have any more questions. So in any case, feel free to send us an email with any question that you may have, which you would like to see answered by one of our experts. And we will forward the questions to them and make sure that you receive an answer to them. Without any further point from my side, and I think also from the speakers, that's okay that we ended up from here. Thank you once again very much for the participation from Tom and from the detailed presentation on the IPR issues with China, and thank you to Richard Deng for the presentation on the matchmaking tour that will be coming very soon in the beginning of April, and we look forward very much to this activity. Thank you very much, and have a nice day.
It's a pleasure. Have a nice